Morning, everybody. Morning, Shehzada. Thank you very much for this opportunity. When I was asked, I immediately took the opportunity because I like talking to fellow lawyers and also learning from others and sharing what I have accumulated over the years. I'm happy I have my colleague, Honorable Faust here, and Nancy from Rex. And I'm also happy to see my friend from Thornton, Grant Thornton. We've known each other for quite some time. And Shehzada, you've done a favor to many lawyers here. It's good to bring these professions together. I cut my professional teeth not in a law firm, but in an accounting firm. And I think there's a lot to share between us, and maybe in the next diversity conference organized by the Tanganyika Law Society, maybe we'll participate, and I think many lawyers will benefit from working closely with the accounting firms, because we need you as much as you need us, but I think we need you more. On the subject I am going to talk about is a subject that isn't really much discussed amongst lawyers, but it should, especially because a majority of the legal practitioners are solo practitioners, but now it's urgent because of the pandemic. We were shocked in our annual general meeting of the number of the lawyers we had to commemorate and to pray for those who have departed. And when I got this subject, and as I was doing my research, I was thinking, who is actually closing those law firms of the lawyers who departed? Who is taking care of the client's business to try to transit it? Who is taking care of the few maybe young lawyers who were employed by these people who departed? And I think it's time for us to start this conversation. And Charles talked about this circular which is going about from the Council for Legal Education. You read the things they want to inspect, and there's nothing about succession. So I think I want to thank Shehzada for bringing this up. It is very timely. The context doesn't actually refer to all the slides that I'm going to talk about. It's only showing what will be covered in the presentation. What is succession planning for law firms? Lawyers always want to go, what is an IPO? Asked. So succession planning, as far as I'm concerned, it has a multiple definitions, but it is simply a plan for the passing on of the baton, or a plan for closing a practitioner's office affairs when you're solo. I looked at Wikipedia. Charles, we also do that. I looked at Wikipedia. It's a process of identifying and developing individuals to succeed senior positions. That is if you're a partnership, if you're operating as a limited liability and you have many employees. Investopedia says it's developing new leaders who can replace old leaders when they leave, looking for greener pastures, or when they retire, or when they're incapacitated or die. That's the plan. Black's Law Dictionary, which we used to do when we didn't have Google, it is an act of a right of legally or officially taking over a predecessor's office, rank, or duties. That's the succession plan. And predecessor meaning if you passed on, that obligation of taking over the rights and duties. So successful legal practice is based on strong credibility and goodwill of established practitioners who have been there for many years and has established relations, clients who respect them, solid foundation. Now, how do you pass that on? kama mimi sasa, how do I pass it on to Nancy, who is a young practitioner growing up? Dr. Faust, how does he pass on his experience? Charles, how do you pass on your experience in the law firm where you are, let alone kwenye bar? So it's the continuity of your firm and the practice depends on the succession plan. It may be formal, it may be informal, it may be happening, but how do you deliver that? Coaching, training, mentoring, developing talent that are within the practice for those who are partnership, and the ability to be able to be like you. Because it's not about machines, it's about people and skills. We know of so many firms that died with their founders. I don't need to name them. You know, the founder is incapacitated and the practice is no more. The founder is dead and the practice is no more. So how do we sustain practice? In a succession planning, what do? You pay special attention to what? Because the stock of a lawyer is time and the people that work with you. How do you develop them in the leadership and how do you groom them? That is where you must pay attention. We don't seek professional guidance. Mutaza told us we need to seek professional guidance on tax matters. HR resources too. Shazada talked about Tanzanian law firms growing and acquiring law firms outside. You need to have the capability and the resources to do that, and that is the human capacity. So we need to get professional guidance that will provide the planning, the tools to deliver the succession plan, to monitor, and to manage the succession plan. We don't know everything. Sometimes we go to hire consultants, and Shazada said so in his presentation. What is it? It's not only for closing the practice. For closing the practice is when you're dealing with a solo practitioner. It is meant to guarantee continuity, that the firm can survive you. And actually that has always been my dream, that the firm we set up can survive me. It doesn't have to die with me. It's about retaining talent, grooming and developing capable practitioners with goodwill close to the seniors, creating second and third tier of practitioners and the right leadership to continue the firm's growth and possibly, of course, to take it to another level. And how do you do it? How do you develop that? It's about retention. We're talking about compensation to practitioners. And what are you offering your practitioners? Do you just pay them their take home? You don't care about their health and their family's health? Do you provide insurance cover for them? Do you provide life cover or incapacity cover? Do you send them to law firms that are friendly for them to learn? Do you send them to workshops, to discussions like this so that they can learn and they can acquire skills? Do you show them the opportunity to stay on in the firm and to learn and to aim higher, to want to stay with this practice rather than going elsewhere? It's about policies and procedures to ensure client practitioner protection. In the event of departures, when a senior partner departs because there's a disagreement, maybe, there's a dispute, maybe, or I want to retire now, or I'm incapacitated. What happens to the client's business? Do you have a system that people will know the client that was being handled by Mrs. Maajar can be taken over? How do you keep the client files and information? We will see below how we are going to do. So it's about those policies and procedures and how you want to manage departures. It matters. It's about policies and procedures for record keeping and archiving and handing over notes, whether you're going on leave or whether you're going to retire, or whether you're leaving, we call in our firm handing over notes. You're going on leave, you've got to write handing over notes to your colleagues, describing the client matter, describing what is pending, describing where you're arriving, describing the contact person to the client, and where the matter stands, and where it is filed. Is it in the O drive? Is it in your own desktop? Where can it be reached? So there are a lot of benefits when we're talking about, and we will describe more the procedures, but what are the benefits for that? It protects you as a lawyer. We know lawyers who have departed and clients went, or creditors went after their estates, because we have no limited liability. So you're protecting yourself when you're planning, so that when you're not there or you're not capable, there is someone who is going to hand over the matters and manage the process of your unavailability. So that protects you. It ensures continuity of the firm and the business, because many firms do not outlive their founders. It protects the clients, their matters and their payments, money, clients' accounts. You heard about clients' account. Those are protected because there is someone who is taking them over, someone who understands them, it protects the information of the client, the files. How do you keep the physical files? How do you keep the digital files? How information is kept, and how the client can continue the matter after your departure or after your death. That we don't have a system in this jurisdiction, and Dr. Fauzi has noted in his book, The Legal Profession in Tanzania. He noted cases where advocates died, and that's many years ago. We haven't been able to rectify the situation, and clients couldn't recover their records or their money already paid in advance. Even now, that is happening with lawyers that have passed. So when you plan, you are actually protecting yourself, and you're protecting the client's matter and their money. How do you build the succession plan for law firms? I'm not talking about an individual law firm here. I'm talking about solo practitioner. I'm talking about partnerships and those who are practicing as limited. It starts from beginning, by the way. Sometimes you're conscious, sometimes you're not cautious. By the type of partners and you choose to partner with, and the type of associates that you're recruiting, actually at all levels. That is where you start planning. You're having to focus in a certain area. And then there is the training and coaching and mentoring and exchange programs and practice development plans. Now, we do training in our practice every Friday. Even today, there will be one at 2 o'clock. That is one. You are training your practitioners in the skills, legal skills. We are doing arbitration now, which is very important because of the new Arbitration Act. We did the beneficial ownership requirements under the Companies Act because it's a new requirement and there's a time frame, and so that our practitioners know what to deliver and what to do with the clients. So these are the coaching that you do. You coach your teams on how to actually do the legal work. And then also you may have exchange programs. When we were with ENS, we used to have this all, but also there are exchange programs with friendly law firms like Allen or Overy that come out here. You can encourage your practitioners, and the practitioners should be on the lookout to see. And then you can do other development plans as you may consider necessary. You undertake the formal and timed performance assessment. That is a very challenging area for lawyers. Assessment of your teams. How are they faring? Who is doing better than the other? And it may be formal, it may be informal, but you have to do an assessment. And then the practitioners also have to know there is a transparent compensation arrangement and also a way of retaining skills. Those are the best that you don't want them to leave. How do you remunerate them so that they stay? In Rex, we know, and Charles knows, we create, we train, and then the richest situation, you don't realize how far you has gone, and you don't elevate them, they leave. The market still can absorb those who leave and go and try to start on their own. So they leave. So Rex became the training law school for many of the young offshoots that we see out there. So when do you recognize that your trainee is ready to go up? That is something. And that has always been a challenge. But also the clear path to partnership, that someone can count the years and what she is bringing in or he is bringing in and assume now I can apply to be partner, or I can start demanding quietly or surreptitiously, anyhow, to be elevated if they are not watching enough for them to be elevated. And then you need also to identify the best. Who is the rising star among your teams, and how you want to prepare them? Do you want to let them know that they are actually being prepared to take over? Those are some of the ways you can create the second tier and the third tier in your firm, so that you can have people who will actually take over the practice when you're not there. I can say with confidence that I think we have people who can take over in Rex when we are done, we are gone. So as I'm saying, it starts from the beginning, but you can start now if you've not formalized the process. You can identify the complement, the experience, the partners that complement your experience. You can hire also laterally. Talk to the practitioners at your level that you think, why don't we team up together? I mean, if you want to build a big, capable Tanzanian law firm, you've got to do that too, lateral hiring. You can also identify skills needed to have practitioners, and you can hire them, new ones. And you can also do intel on the competitor and pick the rising star from the competitors if you get the appropriate intel. And then you can actually grow. And so, but also look at the nature of the compensation that you're giving, and that is always a big challenge. Because when you offer compensation in a way that it's a monthly, it requires continued income, and that may be a challenge. But if it's a question of profits, it may be easier because you take what you can, what you have, and what you don't have. When you do a practice of salaried partners and practitioners, that is when, my friend, you have a situation where you have to go to a bank. We've done that many times. And the banks will give, as long as you have your books of accounts that have a history. If you don't keep proper books of accounts and you don't have audited accounts, the banks will politely say, we don't give lawyers, but they actually give lawyers, and we always go to the banks and they give. And then establish the policies that, for example, how do you receive new matters? In a way that is transparent. Conflict check, matter number, which is shared by everybody and kept by the accounting office. That will ensure that you're not there, everybody knows this client's matter number is this one, this is where we stand. And then the recording. Storage of clients' information. Physical files, the registry, who is maintaining that registry, the numbering, he was talking about color coding. How do you identify your files? And then the access of and sharing information. We have what we call O-Drive. That is where everybody can go and get, and makes life easier, because when you're doing a contract, you can go into the O-Drive and you will get formats there. So how do you keep that information there so that every practitioner can actually access that information? And how do you create, when you have a major client and you're doing a due diligence, you can create a common file where everybody can access, which means that client is not dependent only on Mrs. Maajar. Mrs. Maajar amegongwa na gari huko, Mwenyezi Mungu apishe mbali, mnaendelea bila shida yoyote. So ikiwa sasa file ni siri yangu mimi, Ukigongwa gari na faili limegongwa gari. And then the succession planning, and I can tell you many are doing that as unconsciously, is the managing transitional client and other information. Ambayo inakuwa based on formal protected storage of record, physically, digitally, nimeshasema, OneDrive, nimeshasema, filing registry where all practitioners can access information. You can always, and there's a registry keeper, you can always say, si tunasema, where Edgar uko wapi, ebu tupe file number so and so. Or the chief accountant, what is the matter number? And when you're billing, you know the matter number. When you're giving your time, it goes into the matter number. So it's uniform, kila mtu anaona. Then the handing over information. And instructions about access to registry, computers and protection. Kama kuna password kwa certain matter, that password anakaa nayo nani? Who keeps it? Is it the chief accountant au ni nani? Information concerning the firm's accounts, liabilities, clients, trust account. Tuna finance partner, lakini kuna accountant. So whether the finance partner kagongwa gari, Mwenyezi Mungu apishe mbali, accounts tunazijua. The chief accountant will be there. Information about firms management, statutory compliance, na licensing, na taxes. There's the account, chief accountant, lakini kuna account information. Details concerning contact person. Kwamba, if I am working for client X, usually kwenye engagement letter itasema the contact person hapa ni fulani, lakini kutakuwa na another second contact person. So that one contact person is disabled, the other contact person, your client will always reach information. Lakini you have also the support secretaries ambao walikuwa nazungumza wale. There are secretaries who are copied in every correspondence because they are actually keeping record of the client's matter. So the client will always know where to go. Hiyo yenyewe ni part of succession plan. Details the relationship. Who is the relationship partner or senior partner or senior associate? It matters a lot kwa sababu those are the people who will be accessed in case of need for succession. Solo practitioner, information will take over practice. Inakuwa information requires about who will take over the practice in your absence, and aware there's going to be a slide on that one. That is very important. Kwamba wewe unakaa ofisini kwako peke yako. Sasa wewe ukagongwa gari tunafanyaje? And other jurisdictions kuna requirement ya information kwa client, and I will share that. Succession plan, nimeshasema tena, it is about training the successors, preparing them, grooming them. That is what you're going to do. Assess the skill gaps ambayo we hardly do, but you know that what you know. If you have departments like we do, you know which departments need to be developed. But also kuna wale practitioners ambao wako proactive. They want to actually develop themselves in a certain area of practice. So you can see pamoja na kama anakuja chambers and partners, anakwenda na participate because anataka kujijenga kwenye certain area. Or they do articles, wanaweka LinkedIn, wanaweka kwenye website because they want to develop that. Help them to do that. Hizo placement imeshazungumza, development training kama CLEs, Tanganyika Law Society, make sure those that you want your practitioners to participate in, unazipiki kama hawaoni, maybe you can encourage them. Internal knowledge sharing, when you're handling a matter, important matter. When we created the teams, we don't only go for the teams that those who understand that particular matter. We put in a whole range of all the practitioners mpaka kule chini kabisa. Now unapo create the team communication, wanakuwepo, so they see and they learn what you're doing at that particular matter. Now wakati mwingine it's good to expose them that way and to discuss these things when they go na inakwenda. You may identify an internal coach, but sometimes when you do it, you're not doing it kwa kusema kwamba wewe ni coacha, but every associate is reporting to a senior associate, and senior associate is reporting to a partner or to a junior partner. So in that way, you are mentoring and coaching all the time. Now you are exposing them to the things that you're doing all the time. So that succession plan, whenever you prepare, is actually to be able to hand over matters without avoiding chaotic handing over matters. So we should prepare a succession plan ambazo zinakuwa formalized. It may be happening in your practice, but you need now to formalize it in a way that everybody knows it's actually happening and you're doing it. And the thing is, of course, it requires a lot of time. Practitioners, we struggle all the time with doing things other than attending to clients' work. Even when we talk of assessment, I can tell you the reality. We would set a date for doing assessment, and that date may go past before we actually do it. You may set a date to prepare that document for succession plan, your date inapita. What happens when you meet as partners, you keep reminding yourself, we have to do this, we have to do this, and that is very important to do. But I talked about getting expert advice. I think it's very important. What I can emphasize here, ni kwamba succession plan is not an option. It is important for your survival. If you don't have it, unajiumiza tu mwenyewe. In other jurisdictions, it is mandatory. Sisi hatuna mandatory. Kwa hiyo nitakuja kuongea baadaye why we need to make it mandatory. I am talking about succession plan for solo practitioners kwa sababu wao, it is actually succession plan when they are not there. In other jurisdictions, it bars in our oblige for them to do succession plan and to include the name of the advocate ambaye atakuwa ndio successor wako, atakaye close your firm. If you are disabled or if you are dead, you have to have that. And I looked at the American Bar Association, the National Bar Association, some other state associations, bar associations, na zote, na UK, they all contain mandatory succession plan, ambayo you must actually tell your client in your engagement letter or in another contractual arrangement that if I'm not here, the law firm of X and Y advocates or attorneys will give you information about your matter. I saw this happening many years ago when I was a very young practitioner, when an advocate passed on. And I remember a senior advocate, Javeri, for those who remember him, was assigned to actually go and fold, signed by the Tanganyika Law Society, to close the affairs of that. And but I have seen here, when solo practitioners die, you find their relatives trying to come in and try to close that, and it becomes very chaotic because their relatives who are not even advocates, practicing advocates. So it's important, and now it is very, very important to have a plan as a requirement. I saw the Council for Legal Education long list of their inspection. Thanks God they are asking us to comment on it. And there's nothing about succession. There is only a lot of things which don't even matter to lawyers. Na hiyo Ale Charles alizungumzia kuja kuhesabu kama watu wana vitabu, which is long overtaken na events. So I think we need to comment on those rules that they are circulating to tell them, you know, this is what we need more than that. Now, Tanganyika Law Society also has to look into that. So I was talking about no mandatory succession planning in Tanzania. Here ndio nimeiona. There is no formal mandatory succession planning, but it is critical because many advocates are also solo practitioners. Section 57 of the Advocates Act deals only, sorry about that misspelling, it protects only payments to advocates who take on matters from deceased advocates, but no protection for clients. And this was also observed by my colleague, Honorable Faust. Section 7 of the Advocates' Professional Conduct and Etiquette Regulations deals with consent of former advocate prior to successor advocate accept instructions inter vivos, not even after the advocate's departure or disability. Without succession planning, succession of firm closing becomes chaotic. Kama tulivyoona nyingi tu, na mifano ipo. I was talking to the young lawyer there, siwezi kutaja majina, a chaotic closing of a very famous lawyer. Ambao utaona kabisa the firm, in extreme cases, the firm, of course, they collapse. But the victim ni nani? Ni clients na employees. Do clients worry about succession? Unajua, unsophisticated clients mara nyingi who don't even know how to get a lawyer or pay, they really don't know kwamba kuna succession. But sophisticated clients, they know. And they want to know about what happens when you die. And I was told on my face, well, before I had partners, kwamba I'm hiring you as an exception, but we don't normally hire solo practitioners, kwa sababu tunaogopa ukifa. I said I was not about to die. He said, who knows? So we're saying who should take responsibility ya kufanya succession mandatory counsel for legal education, because it is provided for in the law, na Tanganyika Law Society. What can they do? So I'm saying develop succession plan policy and rules. Bar associations globally, they do that. Require mandatory compliance by law firms. If law firms don't self-regulate, this will be imposed by law, kama vile mnavyoona tunavyofanya. Develop succession plan formats na monitoring tools ambazo lawyers can actually pick on, and I saw that from the one of the American states, where they have a model planning ambayo inaweza kuwa adopted by law firms. Unaijaza, unapeleka. Like also for them, the indemnity insurance requires you to have a succession plan, maana wanaogopa people can come after them. Sasa sisi hatuna chochote, na bahati tu ni wateja bado hawajajua, wakili wangu kafa, mimi hata sijui nifanyeje, mafaili yangu hata sijui niyapateje, na mimi nilikwisha kumlipa pesa, inakuwaje, wala hajui pa kwenda. And I think these things ni vitu ambavyo vinatuchafua sisi mawakili kwa kweli. So na sasa ni wakati wengi tunaondoka very very fast because of the pandemic. Kwa ni wakati wa kuanza kuangalia kwamba tujitengeneze, tujiweke vizuri. Na Council for Legal Education should monitor and evaluate compliance through annual reports or other statutory reports. Kwa mfano kwenye audit, kama you are audited, there must be statutory mention kwamba you have a succession plan ambayo ipo especially for solo practitioners, wale ambao wako partnership, at least someone knows where to go and what to do. Kwa hiyo hizi ziwe kuna requirement. I was just saying, showing where I got some of the information, because it's not anything that we have, and you can see that. And that's about it. Naweza mkauliza maswali.
Thank you very much.
Na washukuruni kwa kunisikiliza.
Mama, we will now welcome you to join the panel for a brief discussion and some Q&A. So if you can just take a seat on the chair next to you.